district courts, the Council of Judges had gone through a very elaborate program to answer all of Judge Morales' questions and concerns regarding transferring the cases from the district courts to the county courts. The district clerk had complied with that process. The county clerk had complied with that process. And the transfer order itself that was in the file ordered that the cases that had been indicted from that last 59 cases was transferred from the indictment court to the county court, and it referenced an Exhibit A. Exhibit A was not included, wasn't filed with the cases. I don't know why the clerk's office was some clerical error. The clerk's office did not include Exhibit A when they filed the order itself in all of the different cases. The public defender's office objected to that. The clerk's office, once being made aware of the clerical error, inserted the Exhibit A into all of the files. So Exhibit A is now actually also part of the order of transfer in all of the files. Judge Morales, not being happy with that for whatever reason, went ahead and granted the plea to the jurisdiction, thereby dismissing them on the clerical error committed in the clerk's office. Again, I want to emphasize this is not something the district attorney's office has any control over. The entire process is something that the district courts set up, the Council of Judges set up. This is a process that's approved by the Council of Judges. The district attorney's office has no control over that. The transfer of the cases occurs between the district clerk and the county clerk. The filing of the order occurs between the district clerk and the county clerk. Whether or not the Exhibit A is part of it or not is all a clerical issue between the clerk's offices. It has nothing to do with what the district attorney's office does. Nevertheless, the remaining 59 were dismissed. Those individuals, if they have not already been released from jail, will be released here today or tomorrow. So that leaves our office in a position of having two choices, basically, on these 59 cases that are remaining now that they are released from jail. We could, one, go back to the grand jury again and re-indict it. There's no bar to us re-indicting the cases, and hopefully the clerk's office would not have a clerical error and some other loophole in the law that would cause a problem with the transfer order. And we would end up with having those cases refiled back in court. We don't have a way, now that the 59 have been released, to get them back into our court system. It takes too long to get the warrants issued. We probably would lose those 59 people. Or, number two, we could just go ahead and appeal what we believe to be an erroneous order on the judge's part, and take these 59 cases up with the bulk of the cases that we are appealing. I want to emphasize why we think it's an erroneous order. Number one, we think that the clerk's order is appropriate. There's nothing wrong with the clerk's order or the judge's order transferring the cases. And number two, if Judge Morales did not have jurisdiction, if he believed that there was something wrong with the order transferring jurisdiction to his court, then the appropriate remedy is to simply transfer them back to whatever entity had transferred it to him, in this case, the grand jury court, and say, I don't have jurisdiction, therefore it goes back to the court that transferred it to him. If I don't have jurisdiction, I can't rule substantively on those cases. If you don't have jurisdiction and you cannot make a substantive ruling on those cases, then you don't have jurisdiction to dismiss the cases. A dismissal is most certainly a substantive ruling on the merits of the case or on the case itself, and you don't have jurisdiction, you can't substantively rule. So we have made the decision that because we don't want to cases just for the pure sake of going out there and getting a warrant filed and sitting around and waiting to see if these individuals should come back into the United States at some point in the future, we are going to go ahead and appeal these cases, much like the other cases that we have in the pipeline to appeal. And we anticipate that the Court of Appeals will, at some point in the future, appellate process is a very long process, But we anticipate that at some point in the future, the Court of Appeals will come back and say, in fact, Judge Morales' rulings and orders were improper, and the way that we thought that the court should have followed was the proper way to proceed. There are perhaps some other issues that you may want to address. I know that the public defender had made some various allegations on our office and against us, and I'm willing to address those if you think it's relevant. If not, then we can move on. Yes, sir.
Have you all made a decision on the original 214 cases, and then also have you all made a decision on what to do with the last 80 cases from the April?
The first 214, we're waiting for the second record. There were two sets of records. We're waiting for the second record from the court reporter to review that to make a final decision. For the 82, those are still pending. We anticipate the judge to grant the plea to the jurisdiction, much as he did on the first 59. Once we have a final ruling from the court on those 82 cases, then we anticipate proceeding with an appeal on those. Right now, those 82 are technically still pending in his court, although they have the same issue as the 59. So we anticipate that the judge will follow through with the ruling, granting a plea to the jurisdiction. It's only those 59 that were set for trial. And, of course, the public defender did not ever want to go to trial on any of these cases, so those are the ones that she was pushing the judge to make a ruling on. She has now emailed and asked the judge to make a ruling on the 82 as well, but those are not in state custody.
I see. So the original 214, are they in play at all in any way?
Well, they're in line for an appeal, but we haven't, like I said, the appellate process is very long. We have to get a record, review that record, then we file the notice of appeal, then we proceed. So, but we have to have the court reporter's record in order to start that process.
So you will appeal those ones?
We anticipate appealing them. I can't guarantee it, but we anticipate appealing them. We have to have that record to make sure that everything was said that needed to be said to preserve the error.
But the 59 you are going to appeal?
We feel very confident. We'll have to again order that record, but we feel very confident that everything was said that needed to be said to preserve the error in the record in order to enable us to make the appeal. This gets very technical, but the ability of the state to appeal a case is very narrow. Generally speaking, the state cannot appeal cases. So the avenue for a state to file an appeal is very, very narrow. So we have to make sure that we preserve the error in that very narrow window and on the very narrow grounds that we can appeal. So we want to make sure that we get the record from the court reporter that we have done everything that we needed to do in order to file the appeal on those very narrow grounds. And we believe very strongly that we did do that. We were watching very closely all of our arguments that we made and watching those cases very closely. After the first 214 that came through, we realized that this was most likely going to end up being an appellate issue and not a trial court issue, that it became apparent to us that we were unlikely to be able to get to trial no matter how hard we were fighting to get these cases in front of a jury of El Pasoans. We realized this is most likely going to end up being an appellate issue. So we were paying very, very close attention to everything that happened after the first 214. We feel very confident that the 59, we do have the appellate grounds there.
What are you doing to change the outcome of these cases? Because this isn't the first time that these migrant cases have been dismissed in the past few months.
Well, I want to change that narrative a little. It's not migrant cases because these are riot cases. It has absolutely zero to do with an individual's immigration status. This is to do with people who have broken the law of the state of Texas in damaging property and destroying property and endangering lives. I have zero concern regarding a person's immigration status. I'm concerned about whether or not they have broken criminal laws. At present, we don't have any additional riot cases in the pipeline. So this would be the last group. This 59 was the last group of rioters that we had in the county jail. So with the release of these rioters out of the county jail, we don't have any others that are pending in court and in jail. So I think that at this point we're transitioning to an appellate battle out of a trial battle. It looks like Ms. Childress, the public defender, and the judge are going to successfully avoid getting any of these cases into a jury trial.
Can these things be done without these individuals being around? For example, if they get deported by ICE before any of this is finished?
There's always an ability, if the case is still pending in court, there's always an ability for a person to plea in absentia, which means enter a plea of guilty in court, even though they're not present in court. They can plea by Zoom. There's a whole procedure to plea in absentia. But the case still has to be pending in court. If there's a plea to the jurisdiction granted and the judge erroneously but nevertheless grants a motion to dismiss, the case is no longer pending in court, and we cannot go to a jury trial without a person being present.
Do you think these cases are being dismissed at all for a political motive?
I think that Ms. Childress, the public defender, has a political motive. I can't speak to the judge's motive. But, you know, look, the public defender, if they wanted to go to trial on this case, they could have gone to trial at any point. A plea to the jurisdiction doesn't prevent someone from going to trial. They could have gone to trial. They could have pled their case. They could have even gotten their clients out of jail. They waived several bond hearings. So at any point, they could have gotten their clients out of jail. They had their clients in jail for 60 days. They could have gotten them out of jail on a bond hearing. They could have entered a plea of guilty at any point. Or they could have gone to trial. We were certainly ready to go to trial on Monday. They could have gone to trial before then if they'd asked the judge and gotten a setting, instead of fighting these pleas to the jurisdiction, which, again, are not, there's something that can be waived at any point. It's not like, again, as with this most recent example, the transfer order was there, just not the Exhibit A. Some clerical error, a loophole in the law, which is something that they could certainly have waived if they had chosen to. So, you know, if that's the case, then what else is there other than some sort of political motive?
Can you just
They've
speak
already
to
been in jail for 60 days, and you're offering time served. Why continue it if they've already served 60 days? I know it's technically not the sentence, but they've already been in jail 60 days.
Well, there's still no finding of guilt, right? So, if there's not a finding of guilt, then that's why they're not held accountable until there's a finding of guilt.
Mr. Hicks, could you address, you know, it seems like there's a lot of work being done on things that are considered to be misdemeanors. Can you just speak to the effort and why pursue that effort?
Well, I think it's important to note that everything that we've done has been responsive to actions taken either by the judge or by the public defender. Nothing that we have done from the very beginning has been out of the ordinary until we've had to react to circumstances imposed on our office by either the court or by the public defender. Fighting for justice in our court system and fighting to hold criminals accountable in our court system is what we do every day. And if we have to fight hard for justice, that's what we do. We fight hard to hold people accountable. If the going gets rough, then that's what we have to do. If the word ever gets out, hey, you know what, at the DA's office, if you make it really, really hard to get that DWI conviction, they'll just give up. Well, certainly we never want to send that message. But DWI is just a Class B misdemeanor. It's just a Class B. Riot is just a Class B, at least the way we indicted it for these people. It's just a Class B misdemeanor. Make it really, really hard and they'll give up. Never. Never. Justice is justice. And we fight hard in our courts every day to seek justice. It doesn't matter if it's a Class B misdemeanor, Class A misdemeanor, or a felony. We fight hard to seek justice. Now, at the end of the day, at some point, we do transition and we make that value judgment between, okay, is this going to be a case that we're fighting hard to get to trial, or are we going to go ahead and fight this case in the appellate courts to get the message across that the correct thing in the law was what we were arguing for from the beginning. Now that there's no one left in jail, and most likely most of them are either being deported or Some are going the amnesty route. Whatever they're doing, right? But the point is, none of them are going to be in jail. We've made the decision to transition from a fighting to get these cases to a jury of El Pasoans to give us their decision on what the case should be. Fine, we're going to go ahead and take this the appellate route and fight our appellate battles.
Are you all getting any assistance from the state or any resources through the Border Prosecution Unit to pursue this next stage?
Well, no, there's no additional resources from the state of Texas on these particular cases. The Border Prosecution Unit is a organization which helps to fund all transnational prosecutions, not specifically riot cases. So that's a little bit of a difficult question to answer, in that we didn't get funding from the BPU to prosecute riot cases. We get funding from the BPU to prosecute all transnational criminal organization type of cases.
So a lot of the prosecution has been in-house in these cases.
As are all of the 20,000 cases we prosecute every day.
And then building off that, some readers have reached out concerned about the taxpayer money being used to try these cases. Do you know how much money has been spent on these cases, and what's your message to those people?
Well, again, my message to anyone concerned about the district attorney's office spending money is that we spend money every day to prosecute criminal actions every day. So there's not any additional money or extra money that goes to prosecuting these cases that didn't go to prosecute every other case that we have in our courts. So you can't say that in our district attorney's office we are dedicating specific money to these cases there's no way to segregate the money that goes to these cases versus every other case. A prosecutor gets paid for their time every day, regardless of whether or not they're prosecuting this case or that case, right? So the time that we spend prosecuting cases is the same across the board for every prosecutor. What's important is, what I mentioned before, is that we fight hard on every single case we have. And just because a public defender or any other defense attorney makes it particularly difficult to go forward on a case doesn't mean that we should ever throw up our hands and say it was too difficult to go forward. If it's ever too difficult to go forward, then we're not doing our job right. Just because it's difficult to pursue justice does not mean that the DA's office steps down. Just because the defense attorney makes our job hard, makes our job expensive, just because the defense attorney is putting up a fight, that doesn't mean that we stop. That doesn't mean we slow down. That means we bear down. We get our fight on. We get our helmets on, and we go into the battle, and we do what we have to do to get justice for the people of our community.
Would you say these riot cases over the past few months have been fair in the dismissals of those cases? And why not go to a different judge during that process?
Okay, two questions. As I understood, your first question was, has it been fair? I don't know about fair. I would say it wasn't properly handled under the law, which is why we intend to appeal them. I think that the rulings have been unlawful. So I think that we're certainly appealing them because we believe that the law was not followed. And why didn't we go to another judge? Because in the Council of Judges, they assigned those cases to that judge. So we don't have neither the Public Defender's Office nor the District Attorney's Office have any control over how the Council of Judges makes the assignment on cases.
So you have anything else to add?
I just, sorry, before you answer that, how rare is it to have a misdemeanor cases where it's dismissed, re-indicted, dismissed, re-indicted, and now appeal? How rare is this?
Well, I would say it's unusual to have a public defender filing motions for private bar attorneys. I would say it's very unusual to have a public defender's office representing not just being appointed to 27 people, but then filing motions on 50 people or 100 people, I think that's very rare. I think it's very rare to have a public defender's office filing pleas to the jurisdiction repeatedly on cases. I think it's extremely rare to have a judge granting pleas to the jurisdiction on cases like this. So the facts and circumstances on this case are very rare indeed. What we've had to do every time something like that has happened is it's certainly very unique. But again, the emphasis is not on what we have done proactively, because we haven't done anything proactively. Everything we've done has been in response to actions taken by the public defender's office, in response to then rulings by the judge, in just an effort to try to get these cases, in particular the people who were in jail, an opportunity to have their case heard in front of a jury. That has always been our goal, to get these cases heard in front of a jury, which I don't think we're going to be able to do.
Mr. Hicks, this question might be for another set of individuals, but I'll ask since you're part of the process. Has this whole series been a blow to Texas enforcement along the border, at least in terms of these initiatives to keep migrants from getting into the country?
Well, again, I don't think that this is an immigration issue. I think this is standing up for law and order in our community, and I think that it has stood up and will continue to stand up as a message to everyone in our community, and even outside of our community, that thinks that they can come to our community and commit a crime. Certainly the district attorney's office has every intention of holding you accountable. If you come to our community and you commit a crime, you're going to be held accountable. If you're in our community and you commit a crime, you're going to be held accountable. The district attorney's office will not hesitate to continue to fight to protect the citizens of our community. We are a community of law and order. We are a community that respects our safety, and our community of good people. Good people in our community. We respect each other, and we expect to be able to be safe with each other. So we certainly will continue to stand up for that, no matter what it takes. My prosecutors are great prosecutors who stand up every day for justice, and will continue to do that no matter what it takes.
All right.
Thank you all.
Thank you. All the time we have, folks.
Thank you.
Thank you.